Good afternoon, everyone, and welcome to Legal Matters, where we tackle the different legal issues and concerns of our teachers, learners, and employees through the expert advice of our Regional Legal Officer, Attorney Angeline Rohel. Good afternoon po, Attorney.
Good afternoon, Ma'am Michelle, and to all our viewers.
All right. So, in our last episode last June, we talked about the various grounds for administrative cases, no, under the provisions of DepEd Order Number 49 Series of 2006, or the revised rules of the procedure in the Department of Education in administrative cases. And for this episode, this July, we shall now talk about the process of filing charges once a certain DepEd personnel is allegedly violating these rules, or an individual finds a DepEd personnel violating any of this. So, attorney, for our first question, what is the first step that an individual who wants to complain needs to do under DO 49 series of 2006?
Ma'am Michelle, to commence an administrative or disciplinary action against a personnel of the department, be it a non-teaching or a teaching staff of DepEd, it all starts with the filing of a formal complaint.
Okay, so that means po, there is a complainant, no, and then he or she needs to file a formal complaint. But for ordinary individuals po, no, na hindi po masyadong aware about legal procedures, may we know, attorney, if there is a specific form of complaint? Pwede na ba yung parang simple letter lang, nag-text tayo doon sa hotlines, doon sa ating mga grievance mechanisms? Pwede na po ba yun? Or there is a certain form for the complaint to prosper under our DepEd order?
That is correct, Ma'am Michelle, because usually we receive complaints filed in different channels. For example, in contact center ng bayan, 8888 Citizens Hotline. So, ang usual instances po na nangyayari doon is that they do not follow the correct form and content of a complaint prescribed under DepEd Order Number 49 Series of 2006. But if we're going to check the provisions of DepEd Order Number 49, no, Section 4 provides for the form of a complaint, meaning when someone files a complaint, there must be some requirements that need to be complied with. As to form, a complaint shall be under oath, meaning it should be written under oath, no, sinumpaan, kumbaga. And it should also be written in a clear and concise language. The reason po behind this is that when we file a complaint, of course, we have to apprise the person complained of the nature and cause of the accusation hurled against him. Because, syempre, we want to give the person complained of the chance to intelligently prepare his defense or answer.
Okay, so that is very clear po, no, kung ano po yung mga yung form. But for those again, attorney, no, na yung mga walang masyadong kaalaman, no, in terms of legal procedures, is it provided in the DepEd order yung sample nitong complaint form, or should we need, for example, to consult a legal counsel on this matter for us to be able to produce this formal complaint?
Yes, ma'am. Actually, under Section 5 of DepEd Order Number 49, meron din po tayong listahan doon ng mga contents ng isang complaint. While the DepEd Order Number 49 does not really provide for a template, no, meaning we cannot really prepare that document by ourselves. We might be needing the help of a lawyer or of a public attorney in preparing it. Meron po tayong certain guidelines as to the content of a complaint. Number one, the content should include the full name and address of the complainant. Dapat ilagay natin doon yung full name natin bilang complainant at kung saan tayo nakatira so that kung meron mang subsequent orders na ipapadala sa mga parties, you will surely be able to receive that document or that order. Second, under the contents of a complaint, we should also indicate the full name and address of the person complained of, as well as the position of that person in the Department of Education. For example, we are complaining about a teacher. We should indicate there in our complaint the position and the school where that teacher belongs so that we can properly refer the complaint to the school's division office concerned. And also, our complaint should contain a narration of the relevant and material facts. Dapat nakalagay po dun sa content ng complaint natin kung ano-ano ba yung mga nangyari, ano ba yung narration, ano ba yung kwento nung kaso or nung bagay na ikino-complain mo. And also, of course, dahil complaint po yan, dapat mayroon din niyang kaakibat o kasama na certified true copies ng documentary evidence mo, gaya ng affidavit ng mga witnesses. And then finally, ang importante din po dito is that ang bawat complaint na ifina-file natin sa DepEd ay dapat may kasamang certification or statement on non-forum shopping bilang patunay na hindi tayo nag-forum shopping, meaning hindi tayo nagfa-file sa kung saan saang agency laban doon sa taong kino-complain natin.
Okay, nabanggit niyo po kanina na kakailanganin yung assistance, no? We might be needing the assistance of a legal counsel, but you've mentioned that we can also consult or ask the help of a public attorney's office para po doon sa mga individuals who do not have the means, no, financial means to consult a private lawyer. So pwede po yung PAW. Pero attorney, sa experience natin dito sa DepEd, under the Public Assistance Action Center or PAAC, no, marami tayong nasi-receive ng mga anonymous complaints. So you've mentioned that in the complaint, kailangan nandoon yung pangalan ng nagrereklamo, no? But how do we deal with these types of complaints na they were lodged anonymously?
Tama po kayo diyan, Ma'am Michelle, 'no? Most of the time we receive anonymous complaints. So while we do not actually prohibit the filing of such complaints, kahit hindi naman po natin sinasabi na bawal 'yun, we should be reminded po that under DepEd Order number 49 series of 2006, particularly under section 8 of DepEd Order number 49, ang general rule po natin diyan is that there should be no action that must be taken on anonymous complaints. So generally, kung anonymous complaint po yan, following our rules under DepEd Order number 49, no action shall be taken on such complaint. Bakit po kaya ganon, no? As we have mentioned a while ago, sinabi natin kanina yung form and content, no? Diniscuss po natin yan. That is the reason bakit generally no action shall be taken on anonymous complaints because meron tayong requirement as to the proper form, meron tayong requirement as to the proper content kung saan dapat sabihin natin dyan yung pangalan natin bilang taong nagko-complain, yung address natin, so that yung taong kino-complain, meaning the respondent in the case, should be properly apprised of the nature and cause of the accusation against him. Okay? But the rule with anonymous complaints po is that while generally no action shall be taken on it, the disciplining authority may dismiss it actually if it is not in accordance with the required form and content. But also under DepEd Order number 49, there are instances when anonymous complaint may prosper. Very rare instances po yan. It is in that case where the disciplining authority decides to adopt the same and file it motu proprio. Meaning kung ang disciplinary authority po, ang disciplining authority mismo, mag-decide siya na i-adapt yung anonymous complaint na iyon. But still, no, when it is an anonymous complaint, we also have to provide for affidavits and other things para naman hindi ma-compromise yung due process.
Okay, I think it is mentioned also in the DepEd order that there are certain categories of the offenses. So I think, no, I hope I'm correct in the thinking, attorney, that the complaints that fall under the grave offenses, no, may merit, no, the yun nga yung decision of the disciplining authority to proceed with the complaint, even if it is anonymous. Okay, so whether it is anonymous or it follows the correct format of the complaint, attorney, once we have the formal complaint, where does the individual now file this? Saan po niya ito dadalhin at saan mag-uumpisa talaga yung pagsasampa niya ng complaint?
Now, ma'am, in determining where to file the complaint, we should also take note of the provisions of DepEd Order Number 49 because under po sa DepEd Order Number 49 Series of 2006, we have different disciplining authorities. And who are they? Siyempre, we have there the Secretary of of Education, no? And then the regional director. The regional director is also a disciplining authority and also the schools division superintendent. So, dapat po nating tandaan kung ang complaint natin is against a presidential appointee. For example, a regional director, an assistant regional director, a schools division superintendent, or an ASDS, or when our complaint is against a non-teaching personnel in the central office, then we should file our complaint with the central office because the disciplining authority there is the Secretary of Education. Now, when the complaint is against a teaching personnel in the region or in the non-teaching personnel in the regional office, no, kung ang kino-complain natin, for example, ay teacher sa Bulacan, teacher sa Bataan, okay? Ang complaint dapat ay i-file sa regional office. Also, kung ang complaint natin ay against a non-teaching personnel in the regional office proper, dapat po sa regional office din i-file ang complaint dahil ang disciplining authority natin dyan ay ang regional director. And then finally, of course, kapag ang complaint natin is against a non-teaching staff in the schools division office, we should file it with the SDO because it is the schools division superintendent who is the disciplining authority in that case.
What if suddenly the complainant decides to withdraw the case or does not want to pursue the complaint anymore? Ano pong mangyayari doon sa proceedings, attorney?
Yes, ma'am. That is a very important matter, no? What happens? Yun po ang usual question natin. What happens when the complainant decides not to pursue or decides to actually withdraw the case? Madalas po may nagtatanong, attorney, kapag ba nag-withdraw na yung complainant, ibig po bang sabihin nun tapos na rin yung kaso? Ibig po bang sabihin nun dismiss na rin yung kaso? So, ang answer po dyan is this. No, the general rule is that ang withdrawal ng complaint, recantation, or desistance of the complainant in pushing through with the administrative case does not automatically result to the termination or dismissal of the case. So yun po yung madalas na misconception, no? Please take note po na just because the complainant decided to withdraw the complaint, hindi po ibig sabihin nun ay automatic decided na or terminated na yung kaso. Ang reason po dito is because a complainant in an administrative case only serves as a mere witness, no? And administrative actions are not made to depend on the will of the complainant. Okay? But please take note po that in certain instances, pwede naman pong mangyari yon na kapag nag-withdraw yung complainant ay hindi na magpo-push through yung case. Kailan naman yon, no? Nangyayari po yon kapag walang sapat na basis para i-continue yung kaso or when the guilt of the person complained of will not be established without the testimony of the complainant.
All right, we shall be talking more about the procedures under DO 49 series of 2006 when we return.
Bida, bida kin! B for best friend, ang mas. I for ingatan, ang kamay. D for distansya, sa katabi. A for airflow, ligtas tayo. 3 B's ay laging tandaan. Bakuna, bayanihan. Bida kid, kaya mo yan. Halina't magtulungan. Ikaw at ako ang bida kid. Sa COVID di ba dadaig? Sa ligtas na pagbabalik. Sama-sama maging bida kid.
And we're back here at Legal Matters. We're still here with Attorney Angeline Rohel, and our topic for this episode is how to file a complaint, no, under DO 49 series of 2006. So it was mentioned during before the commercial, attorney, that it doesn't mean that a complainant withdraws the case, that the complaint will not push through. So there are certain conditions when a certain case can prosper, no. It depends on the nature of the case po siguro, no, attorney. But what are now the actions that must be undertaken? So in certain instances na nagwi-withdraw, but kadalasan naman po, no, in our experience, the complaints really prosper. And so after the complaint is filed, what are now the actions that must be undertaken after the complaint is filed properly and appropriately?
Okay, ma'am. So, once a complaint is filed, what happens? Ang nangyayari po dito is that una sa lahat, ang disciplining authority po will issue an order for the conduct of a preliminary or fact-finding investigation. So, ang necessity po nito is because magkakaroon ng investigasyon base doon sa complaint na na-file noong tao. So, sa investigation po na iyon, no, in that same order issued by the disciplining authority, magkakaroon po tayo ng hearing officer. And usually for places or schools division offices where there is a legal officer, ang legal officer po ng division office ang nade-designate na hearing officer. Okay, ano po ba ang trabaho ng isang hearing officer? Now, in that preliminary or fact-finding investigation, the hearing officer will determine if there is prima facie evidence that the person complained of committed the offense. So the hearing officer will now investigate, no? Posible ba na ang taong ito, itong taong kino-complain ay talagang ginawa yung offense complained of, no? Now, after that preliminary or fact-finding investigation, ang hearing officer po will submit an investigation report and recommendation to the disciplining authority. And then the disciplining authority will review yung investigation report na yon, along with the records of the case to determine if the issuance of a formal charge is proper. So kung sa tingin po ng disciplining authority ay talagang may posibilidad, malaking posibilidad na yung taong ito ay gumawa ng offense charge against him, posible pong magkaroon ng issuance ng formal charge. And once meron na pong formal charge na na-issue, a formal investigation committee will be constituted pursuant to Section 21 of DepEd Order Number 49, Series of 2006. Yun pong formal investigation committee po na yon, yun naman ang magko-conduct ng formal investigation, and sila rin po yung magsasubmit ng report sa disciplining authority. And finally, kapag tapos na po yung naging investigasyon ng FIC or ng Formal Investigation Committee, ang disciplining authority naman po ay mag-i-issue ng decision o resolution doon sa kaso.
Okay, so if attorney, if the disciplining authority will decide that they will push through with the case, this is when the formal investigation commences, no? And a formal charge will be made against the concerned personnel. So at this point po ba, an administrative case is still pending, attorney?
Okay, ma'am. That's also one of the most asked questions that we have in the legal unit. Ang question is, attorney, kapag po ba mayroon nag-file ng complaint sa akin, ibig po bang sabihin nun mayroon na akong pending administrative case? The answer po is the mere filing of a complaint, if it is just in the level of a preliminary investigation or fact-finding investigation stage, sa punto po na yon hindi pa pending ang administrative case. Ang administrative case po ay maititreat lamang na pending na kapag nagkaroon na ng issuance ng formal charge. So kung meron na pong formal charge, at that point, an administrative case is already considered pending.
That is very clear, no? It is only considered a pending administrative case against a personnel once there is a formal charge given by the disciplining authority. So, how about if there this concerned personnel meron na po siyang complaint, no? Even without the formal charge. is the preventive suspension automatically served to this person being complained of, attorney?
Ma'am, as to preventive suspension matters naman po, no, we have to look into Section 15 of DepEd Order Number 49 Series of 2006. So kung titingnan po natin yung provision niyan, ang preventive suspension po ay pwedeng ma-serve upon the motion of the complainant, meaning ang complainant mismo ang magre-request na ma-impose ang preventive suspension laban doon sa person complained of. Or pwede rin naman po na yung preventive suspension upon the findings of the disciplining authority na proper ang issuance nito, pwedeng motu proprio issuance po ng preventive suspension. But we must take note po that preventive suspension should only issue immediately upon the issuance of a formal charge. So kung wala pa pong formal charge, no, hindi pa po pwedeng magkaroon ng preventive suspension. Now, in questions about ano po ba yung mga kaso na pwedeng ma-subject sa preliminary or preventive suspension, sorry, sa preventive suspension ang isang teaching or non-teaching personnel. No, under DepEd Order number 15, DepEd Order number 49 series of 2006 section 15, no, ito po yung mga instances. Please take note po, ito lang po yung mga instances na maaaring mag-issue ang preventive suspension. Number one, kung ang complaint po ay about dishonesty. Second, if the complaint is an offense called oppression. And then, the complaint is about grave misconduct or neglect in the performance of duty. Or if there are reasons to believe that the respondent is guilty of the charges which would warrant his removal from the service. But please take note po, a preventive suspension is not a penalty. It is not yet a penalty kasi wala pa pong finding of guilt. So ang purpose po ng preventive suspension is to prevent the accused from using his position and powers to influence potential witnesses or tamper records within his reach. If he is a head of that office, if he is a supervisor, then it may be necessary to impose preventive suspension para hindi ma-impluwensyahan yung mga possible witnesses at possible evidence that can be presented against him.
If attorney, the formal charge is run its course and the complaint personnel is found guilty, no? And then meron na siyang sanction o kung ano man yung decision, no? Pwede po ba siyang our motion for reconsiderations or appeals allowed under DO 49 series of 2006?
Yes, ma'am. Actually, kapag nagkaroon na po ng decision, for example, the decision imposes the penalty of dismissal from the service, hindi pa naman po doon nagtatapos because there are still some remedies under DepEd Order number 49 series of 2006. So those remedies are available for the respondent. We have their motions for reconsideration and appeals. So similar to civil and criminal cases, yun pong appeals and motions for reconsideration are allowed. So, kailan po ba natin pwedeng i-file ang motion for reconsideration? So, pwede po tayong mag-motion for reconsideration kung sa ating palagay ay meron tayong bagong ebidensya na nadiskubre, meaning merong ebidensya na hindi present at the time of the hearing. No? Kung saan kapag ipinresenta mo tong ebidensya na ito, ay maaring magbago yung course or decision doon sa kaso. But please take note, pag sinabi pong new evidence, dapat hindi ito existing at the time na nagkaroon na ng hearing or ng trial. Okay? And then, pwede rin pong magkaroon ng motion for reconsideration kapag sa tingin natin ang decision na rendered ng disciplining authority ay hindi supported ng evidence on record. And then, if there are errors of law or irregularities that have been committed to the prejudice of the person, of the respondent. And then for appeals naman po, we can appeal decisions of the regional director imposing a penalty of 30 days, exceeding 30 days suspension or fine in the amount of 30 days salary. So pwede po nating i-apela yan sa Secretary of Education within 15 days from receipt of the decision. So please take note of the reglementary period po. Meron lang tayong 15 days from receipt of that decision to appeal it. Because kapag lumagpas na po sa 15 days, hindi na po maaaring i-avail yung remedy of appeal. And then, from the Secretary of Education, kung sa palagay po ninyo ay hindi pa rin po tama yung naging desisyon, you can still appeal it to the Civil Service Commission or the CSC. Now, pending the appeal, the same shall be executory, no? Except where the penalty is removal. In which case, ang decision po na nire-remove na sa service ang isang respondent ay maaari lamang ma-execute kapag na-confirm na po ng secretary. So kung ang mga inaapela po natin ay mga suspension less than 30 days, no? Executory po yan, immediately executory yan. Pero kung ang mga decision ay yung tinatanggal na yung tao sa serbisyo, hindi po yun immediately executory unless or after confirmation of the secretary, doon pa lang natin siya maaaring i-execute.
It's very clear, attorney, no, when do we consider motion for reconsideration and when do we file an appeal? Kasi doon sa motion for reconsideration, there are three conditions, no, kung may bagong ebidensya o kaya hindi supported by the evidence presented, yung naging desisyon, or there have been errors of law or irregularities. But in the absence of those three conditions, they will make an appeal. No? So just for the information and guidance of our DepEd personnel, the difference between the motion for reconsideration and an appeal. You've mentioned a while ago that when a decision is made by the disciplining authority, whether it's the secretary, the regional director, or the SDS, one of the most gravest or yung pinaka-ultimate na penalty, no, or to be served, no, for the concerned personnel is dismissal from the service. But like what I've mentioned a while ago, I think yung mga nag-merit ng dismissal from the service are the grave offenses, no? Just to inform our viewers, attorney, what are these grave offenses that may cause dismissal from the service?
Actually po, napakarami po nung mga offenses na maaring mag-result sa dismissal from the service. Pero if you will check DepEd Order number 49 series of 2006, ito po yung mga usual na offenses na punishable by dismissal. Number 1, dishonesty. Second po is gross neglect of duty. And then we also have grave misconduct. Yan, usual po yan. And then being notoriously undesirable, it's also punishable by dismissal from the service. Now, for offenses like oppression, no, and disgraceful and immoral conduct, ang mga yan po ay nag-amount to dismissal from the service only upon a finding of second offense. Meaning, kung pangalawang beses na napatunayan na guilty ka sa oppression or disgraceful and immoral conduct, sa una, maaaring suspension pa lang ang katapat. Pero sa pangalawa po, dismissal na po yun.
Of course, we don't want ourselves to be given that penalty or decision na madidismiss from the service because aside from the yung magiging image po natin that we were dismissed from the service, no, it also carries with it yung mga consequences. I mean, in terms of the benefits, no, that we will get upon retirement. For example, once as personnel is dismissed from the service, what are the benefits, no, or the consequences na they will experience po, attorney?
Tama po ma'am, ang dismissal from the service po ay talagang napakasaklap, no? Because dismissal from government service shall carry with it, number 1, cancellation of eligibility. Okay? And then, forfeiture of retirement benefits. So parang lahat ng iyong pinaghirapan ay mapupunta sa wala. And ang pinakamatindi po dito, no, kapag provided sa decision na you will be perpetually disqualified for re-employment in the government service. So, ibig sabihin, kapag ikaw ay na-dismiss, maaaring kahit kailan hindi ka na makakapag-apply sa gobyerno at hindi ka na makakapagtrabaho sa government because there is perpetual disqualification for re-employment in the government.
Okay, so I think those consequences are really parang worse, no? Talagang napaka-saklap, sabi nga po ni attorney. And so, attorney, having discussed all of this last June and July, yung mga naging, yung mga grounds for administrative cases, and even the tedious process. Kasi, can you mention a case na what is the longest duration na meron tayo ngayon dito sa Region 3, yung pinakamatagal na hindi pa nare-resolve kaya attorney? Do we have any?
So far po, okay naman po sa records. Ano naman po, meron po tayong mga pending but for confirmation na po ng central office, yung mga dismissal cases.
Okay. So, and I hope no, we are doing this episodes for legal matters actually to guide and really parang discourage also our personnel na wag na po tayong gumawa ng mga violations under DO 49 para hindi po tayo iko-complain at we don't need to undergo this process of being complained of, no? Kasi meron din pong effect yon in our image as a public servant. And so, attorney, what is your final message to all our viewers relative to our topic today?
Yes, ma'am. Actually, tama po kayo doon. Number one, ang pinaka-message po ng ating episode is that sana hanggat maaari iwasan na natin yung makapag-commit ng mga ganitong klase ng offenses para hindi po gaanong hassle sa atin at hindi rin po hassle doon sa taong nagko-complain laban sa atin to prepare these requirements in order to charge you with an offense. But in the instance that talagang kailangan pong mag-file ng administrative complaint laban sa iyong colleague or laban sa isang co-teacher, no? Or kung kayo man ang mafa-filean ng kaso, we should be reminded that hindi rin po basta-basta ang pag-file ng mga cases na ganito because of course we have to comply with the requirements of the law, we have to comply with the required form and content of a complaint so as not to compromise the requirements of due process dahil at the end of the day, we have to respect what the Constitution provides that we also have to give due process to these administrative complaints. We do not want to confront our personnel with baseless and anonymous complaints and that we have to assure that the minimum requirements of due process like being informed of the nature of cause and accusation against that person, dapat masunod po natin yon at all times.
All right. Thank you very much po, attorney. And once again, we had a very comprehensive explanation and about the O49 series of 2006 or the revised rules of the procedure in the Department of Education in administrative cases. And of course, again, time and again, we learned a lot today from our Regional Legal Officer, Attorney Angeline Rohel. And join us again for next month for another episode of Legal Matters. I am Michelle Lacson from the Public Affairs Unit of DepEd Region 3. Good afternoon.